Rescission of contracts and the restoration of original status. What if you could rewind a bad agreement like it never happened? In this video, we reveal how contract rescission restores your original status and the lawful tools you need to do it right. Rescission is the legal act of canceling or undoing a contract, thereby restoring all parties to the positions they held before the agreement was made. In private remedy and trust administration, rescission may be invoked to correct contracts entered into under mistake, fraud, duress, or lack of full disclosure. When rescission is properly executed, the contract is treated as though it never existed. Essential elements include a clear declaration of intent to rescind, notice to the other party, and the restoration of any benefits received. Often, rescission is supported by affidavit and evidence, and becomes part of an administrative process that includes opportunity to cure or rebut. In commercial law, rescission can also involve the revocation of signatures, withdrawal of consent, or return of instruments. Its purpose is equitable, to nullify unjust or unconscionable obligations. When contracts are adhesive or silent on critical rights, rescission becomes a pathway to restoring commercial sovereignty. Footnote: this section outlines how rescission serves to nullify defective contracts and restore parties to their original positions when equity demands correction.